Assalamualaikum. My name is Nur Najwa binti Rahim from DPM6B.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Hana Nazira binti Jasmi. I am from DPM6B and
Hi, Assalamualaikum. My name is Nurajina binti Mahusin from DPM6B.
Okay, Assalamualaikum. My name is Nur Najwari binti Rahim. In this video, our group will present about the procedure of repossession, which is this is our final project for this semester. Now, I will continue with my part, which is the definition of hire purchase. Hire purchase is defined as an agreement for buying expensive consumer goods, where the buyer makes an initial down payment and pays the balance plus interest in installment. In other sentences, hire purchase is an option of financing asset for use whereby the financing company lend the goods on hire to the buyer against small installment called as hire charges, and the buyer can get the right by using the asset and must to paying all such installments spread over a period time. According to Section 2(1) of the Hire Purchase Act is a letting of goods with an option to purchase and an agreement for the purchase of goods by installments. So, at the end of a hire purchase agreement, when they already own the goods or vehicle, and that time they can do whatever they want. Okay, there are three parties that involved in a hire purchase agreement. Firstly is a seller. Seller is a person that sell the goods. Secondly is the hire. Hire is a person who takes or has taken goods from an owner under a hire purchase agreement. And the last is owner. Owner is a person who lets or has let goods to a hire under hire purchase agreement and includes a person to whom the owner's right or liabilities under the agreement have passed by assignment or by the operation of law. Okay, now I will continue with formation and content of hire purchase agreement. Firstly is written agreement. So as we can see, according to Section 4A(1) of the Act provides that hire purchase agreement must be in writing. Okay, for example, a handwritten agreement which cannot be read and understood is regarded not to be in writing and it's become a void. Next, according to Section 4A(1)(a) of the Act also provides that hire purchase agreement shall be in national language or English language. Okay, the Act does not stipulate the language that is required to be used on agreement, but it is a normal agreement for using English language or Malay language. Okay, if the hire signed a document in a language that he doesn't understand, the agreement will be void. Okay, secondly is signature of parties. According to Section 4B(1) of the Act provides that every hire purchase agreement shall be signed by or on behalf of all parties to the agreement. Okay, this means before any hire required by dealer to sign the agreement, dealer and hire have to make sure the document was complete with the details. Okay, according to Section 4B(2) of the Act provides that no dealer, owner, agent or person acting on behalf of the owner shall require the intending hire to sign in complete form. This section defines that non-compliance will be void the agreement and the person is guilty of an offence. So in Section 4B was introduced about the problem between Ming Lian Corporation Sendirian Berhad 1974. In that case, the defendant had signed the hire purchase agreement for a motor vehicle. Certain portion of the documents were left blank at the time of signature and the particulars were filled in after the agreement was signed. It was held that hire purchase agreement was valid despite the fact that there were blanks which were filled up after execution. Nevertheless, the decision in Myung Lian's case is no longer a good law as we have Section 4B. Okay, thirdly is about content of hire purchase agreement. Okay, in Section 4C of the Act provides that hire purchase agreement shall contain the date, the number of installments to be paid under hire purchase agreement, the amount of each installment, and the person, whom, and place at which the installment are to be paid, the term for payment of each installment, the description of details of the goods, and the last is address of the goods. Okay, for the total setting is deposits, delivery of freight charges, vehicle registration fees, insurance, total amount less deposit, term charges, annual percentage rate, balance originally payable under the agreement, and the last is total amount payable. Okay, if the hire failure to comply with all requirements of Section 4C will render the hire purchase agreement is void. Okay, for the last formation and contents is service of documents. Section 5(1) of the Act provides that makes it mandatory that the owner serves to the hire and the guarantors a copy of hire purchase agreement within 21 days after it is made. If the total amount payable under the agreement includes payment for insurance, the owner must serve a copy of the insurance policy or a statement in writing within 7 days of the receipt of such policy by the owner as provided by Section 5(3) of the Act. Okay, now I will continue about the definition of repossession of hire purchase. Okay, repossession is the term used to describe the taking back of property after a borrower has defaulted on payment. The lender either repossesses the collateral or pays a third-party service to do so. Okay, when you default on your hire purchase agreement, it means you have failed to fulfill your commitment to the bank. When this happens, the bank can repossess your car. So, generally, repossession can happen when you fail to pay for 2 consecutive months' payment or when you fail to pay your last payment. Okay, repossession can happen when, in the case where the hire is the case, a default in payment for 4 months give the bank the right to take possession of the car. Now we'll continue about the Act of Repossession. According to Section 16(1), requires that the owner to supply the hire with a notice of repossession. In other words, notice of repossession must be given to the hire when goods are to be repossessed. Before the owner exercises his right to repossess the goods, the owner must first assure that the balance of the loan to be paid by the hire must be more than 1/3 of the purchase price of the goods hired. Okay, by fulfilling this requirement, only then the owner will have complied with the requirement that the hire has default 2 successive installments. Under Section 16(1), the owner must serve the hire a 21-day notice of intention to repossess in writing as set out in the 4th schedule. Okay, the written notice must be serviced in compliance with Section 43 of the Act. The owner can retake possession of the goods only after the expiry of the notice period and if the overdue installment are not settled by then. In the case of Pang Brothers Motor Sdn Bhd versus Lee Ark Seng, where a car was taken by the respondent on hire purchase agreement with the appellant, the respondent failed to pay the installment due and the appellant issued a notice under Section 16(1). The issue was whether the notice was in fact served. The court held that Section 16 clearly specified that the period before which the seizure can take place shall be not less than 21 days after the service of the notice. In section 16(1)(a) provides that if the payments of installment made amount to more than 1/3 of the total cash price of the goods comprised in a hire purchase agreement, and there had been 2 successive defaults of payments by the hire, the owner shall not exercise any power of taking possession of the goods comprised in the hire purchase agreement arising out of any breach of the agreement relating to the payment of installment, unless he has obtained an order of the court to that effect. In section 16(1)(a), requires an order of the court to be obtained by the owner before repossessing the hire's good if the balance of the loan is less than 1/3 of the purchase price of the goods. This section governs a situation where the hire is the case. In section 16(2) provides that the owner is excused from complying with section 16(1) where there are reasonable grounds for believing that the goods will be removed or concealed by the hire contrary to the provision of the agreement. The onus of proving the existence of those grounds lies upon the owner. Section 16(2) makes sense because hires who have defaulted in their monthly installments have been known to disappear and to remove the goods or conceal them in order to prevent the owner from repossessing them. Okay, for the last act of repossession of hire purchase is in section 16(a) provides that a hire who returns the goods comprised in a hire purchase agreement within 21 days after the service on him of the notice in the form set out in the first schedule shall not be liable to pay the cost of repossession, the cost of incidental to taking possession, and the cost of storage. It is important to note that upon service of the notice under the fourth schedule and after 21 days had lapsed from the service of the notice, the owner may take possession of the goods. So that's all from me. I will pass to the next presenter for more explanation about procedure of repossession. Thank you.
Thank you to Nur Najwarin for the information about introduction before. Next, I'm going to continue about the 2 types of loan and the procedure for repossession. Before that, I'm going to introduce myself. My name is Hanana Hazira binti Jasmi and I am from DPM 6B. I'm going to continue to the presentation. There's a 2 types of loan. The first one is unsecured and the second one is secure. The unsecured one is a personal loan, allow you borrow money without providing collateral. And the secure one is a secure loan, required some kind of security and insurance that you will pay. But if you want to borrow the loan, you must not forget about the 3 things when you sign the loan paper. The first one is you will pay the loan back if you borrow the loan. The second one is if you fail to pay the loan back, the lender had the right to take the vehicle and sell it. And the last one is if the automobile was not worth enough to pay off the entirety of your debt, you will still own what was left. Okay, now I'm going to continue to the procedure of repossession. In section 61, required the owner to supply the hire with a notice of repossession. In other words, notice of repossession must be given to the hire when goods are to be repossessed. Before the owner exercises his right to repossess the good, the owner must first assure that the balance of the loan to be paid by the hire must be more than 1/3 of the purchase price of the good hired. By fulfilling this requirement, only then the owner will have complied with the requirement that the hire has been defaulted to successive installments. Under Section 61, the owner must serve the hire a 21 days notice of intention to repossess in writing as set out in the first schedule. The written notice must be serviced in compliance with the Section 43 of the Act. The owner can retake possession of the good only after the expiry of the notice period and if the overdue installments are not settled by then. For example, in case in Pang Brother Motors Timberhut vs. Lee Akseng, where a car was taken by the respondent on hire purchase agreement with the appellant. The respondent failed to pay the installment due and the appellant issued a notice under Section 61. The issue was whether the notice was in fact served. The court held that the Section 16 clearly specified that the period before which the seizure can take place shall be not less than 21 days short of the statutory minimum requirement and the notice. However, the date specified in the notice was therefore bad in law even if served and its effect was therefore null and void. According to Section 61, provide that the hire who return good comprised in a hire purchase agreement within 21 days after the service on him of the notice in the form set out in the fourth schedule shall not be liable to pay the cost of repossession, the cost incidental to taking possession, and the cost of storage. However, it is important to note that upon service of the notice under the fourth schedule and after 21 days had lapsed from the service of the notice, the owner may take possession of the good. Okay, so now I'm going to continue to the procedure of after repossession. After repossession, the owner must not sell or dispose of the good for 21 days according to Section 17. By the virtue of Section 71, no person shall undertake repossession of good comprised in hire purchase agreement without writing permit issued by the controller. Any person who is contravenous subsection shall be guilty of an offence under this Act Section 17(2). It is an offence to appoint a non-permit holder to undertake the repossession of good comprised in hire purchase agreement in Section 71 and Section 17(2), while Section 18 of the Act lays down the various rights and immunity enjoyed by the hire. Therefore, it is important for the owner to serve a notice in the form as set out in the fifth schedule on the hire and every guarantor of the hire within 21 days after the owner has taken possession of the goods. In Hong Leong Financian Berhad Rajandram, Augustine Paul J. stressed the importance for the owner to comply strictly with provision regarding notice as set out in the 4th and 5th schedule. As mentioned earlier, if the owner failed to serve the notice in the form set out in the 5th schedule, his right under the hire purchase agreement there replenished and determined. This is virtue of Section 16(c). But the owner may apply to the court immediately for an extension of time as contained in Section 41 of the Act. Such an application shall not be done by ex parte because the hire right will be prejudiced. However, if the hire then recovered his good repossessed, the agreement has the same effect as thought notice had been given. In other words, the hire purchase agreement is deemed to continue in force between the parties. Under Section 71, it is provided that where the owner has taken possession of the grounded Section 16, he must not, without the hire consent, sell or dispose of them or part with the possession thereof until the expiration of 21 days after the date of the service of the notice set out in the 5th schedule. In addition, where the owner has taken possession of any good, the hire shall be liable for the cost of repossession. The hire has no right to deny his liability to pay the cost because it is stipulated in the hire purchase agreement between the owner and the hire. The hire right is only to the extent of contending total cost incurred when the owner took possession of the good. In Ko Tao Sui versus United Engineer, the court observed that the appellant, it is higher, had contractually undertaken to pay such costs and expense. He could not thereafter dispute his obligation to pay the actual insured. Next is, in Section 71 and Section 72, deal with the issue of permit for repossession. Only a person that was given a permit can execute the repossession process. The permit is issued by the controller, which means that it is directly controlled by the government. Therefore, when the owner engages an agent to execute repossession, that particular agent must have a permit. Last but not least, under Section 18.4, it's provided that where the owner intends to sell the good by public auction, he must serve on the hire a copy of the notice of such public auction not less than 14 days from the date that said auction is to be held. Therefore, when the owner takes possession of goods and required to sell them by public auction, he is responsible to ensure that the goods are sold at the best market price. If the owner fails to comply with such requirement, the hire will be stopped from reducing his losses. This was enunciated by the Yusuf Muhammad J in the case of Hong Leong Finance Berhad versus Lee Chiang Heng. That's all from me. I'm going to pass this to the next presenter, Nurul Adlina. Thank you.
Assalamualaikum. Hi, my name is Nurul Adlina binti Muhammad Hussein from DPM 6B. Okay, I will explain about the right and protection of hires, and next is about the ethic of towing a car. First, I will explain about right and protection of hires. In the course of purchasing the good, a purchaser that will become a hire upon completion of the hire purchase agreement will deal with a dealer or seller. There will be a case where dealer or seller commit the act of misrepresentation toward a purchaser. For instance, give wrong information as to whether the goods was manufactured with the intention the desired purchaser, because a dealer or seller knows that a purchaser may not interested to buy the car if he knows that the car manufactured in certain particular year. In circumstance, a hire is entitled to claim from the owner or any person making misrepresentation in the course of purchasing or negotiation that leading to the hire purchase agreement. A hire may sue the dealer or seller or the agent as well as the owner for damage and rescind the hire purchase agreement. Next, the right and protection of hire according to the HPA will be available once the hire purchase agreement has been concluded in accordance with the requirements imposed by the HPA. Before that, HPA means hire purchase agreement. Okay. Let's continue. Those rights and protection are derived from the implied conditions and warranties that are given to the good hired. On the other hand, as far as the right and protection for the owner is concerned, it will be related to the right to repose the good hire once the hire default in making closed payment. The implied conditions and warranties that are applied for the good hire to the hire similar to the implied conditions and warranties that are offered to the goods that are sold according to the Sale of Goods Act 1957. Okay, next we will go to car towing ethic. There are 4 ethics we all need to know. Well, the first is about EPS card. Before that, EPS means Agent Perolehan Semula in Malay. Okay, continue. Car towing agent must have an EPS authority card from KPDNKK before they towing the car. The second is about public holidays. So you must be asked why with public holidays, right? Okay, like this. Towing agents are not allowed to tow cars on public holidays, and they can only tow cars on weekday from 9 a.m. to 9 p.m. only. The third is about regarding the letter of instruction. The agent must submit to the buyer, namely the letter of instruction to pull the car from the financial institution and the court order. Okay, the last ethic we need to know is pay over 75%. The agent is not allowed to withdraw the car if the payment excess 75% of the car loan. Okay, to make it easier for all of us to understand about the ethic of towing a car, let's watch a summary of the video on the ethic of towing a car. Okay, let's watch.
Mang buta, banyak gadis cantik sini. Hoi, abang manis. Bang, ni kereta abang ke? Ya, kereta saya. Cantik. Handsome bang. Macam tuan dia kak. Tapi sayang, abang dah lama tak bayar. Jadi kita orang datang sini nak tarik kereta ni.
Dah, jangan cakap banyak. Abang bagi kunci. Kita orang cair. Orang tak ada cerita panjang.
Sesuka hati korang nak ambil kereta aku Ha? Ni, kad permit EPS ada tak?
Kad EPS lah. Berani tanya. Adalah. Ini siku pada sekali aku lesing barang kau tahu.
Okey abang simpan lesing-lesing siku-siku abang tu. Saya tak takut. Okey abang tak apa. Yang seorang lagi? Ada tak? Ha? Korang, kalau tak ada kad permit EPS tu, tak payah datang sini. Tak payah cakap dengan aku. Kad permit EPS tu kena ada, baru boleh tarik kereta ni. Ni nak datang gangster-gangster, konon lesing-lesing. Bawa lah berapa ramai gangster pun, kalau seorang je ada kad permit tu, tak boleh. Ini kesalahan besar tau tak? Aku boleh report polis yang korang ni gangster datang kacau aku.
Tak ada lah bang, mana ada ugut. Kita orang gurau je kan. Kau lah ni, manakah kau?
Kau lah, aku dah cakap suruh bawa. Okey, sekarang ni, korang dua balik, cari kad permit EPS tu dulu, baru datang sini cakap dengan aku. Balik. Tata. Bye. Assalamualaikum. Li, betul ke kat sini rumah dia?
Aku rasa dekat-dekat sini lah. Aku tak ingat nombor berapa.
Tak apa, kita jalan terus. Aku rasa Li, depan ni Li. Bila
Kita
aku
jalan.
cakap stop Li.
Mana?
Li, stop Li. Li, tu dia Li.
Dibawakan kepada anda oleh sumbangan.com.
Mama Li. Mama. Hello, Abang Handsome. Kami dah sampai. Kad EPF, kad ATM semua kami ada bawa.
Bukan EPF lah. EPS.
EPS. Mana kadnya? Ada ni lah. Wah. Tak payah banyak bunyi lah. Bagi je lah kunci kereta. Oh, nak kunci kereta?
Yalah.
Tak boleh. Dia ni macam-macam lah. Bila suruh bawa kad, dah sampai tak nak bagi pula kunci. Okey. Kad EPS ada tu, itu bagus. Satu kejayaan. Tapi masalahnya sekarang ni, korang masuk rumah aku tanpa izin aku. Tak boleh. Ini salah.
Tak boleh. Betul?
Macam-macam lah dia ni.
Keluar lah.
Kau nak keluar?
Okey.
Nak keluar? Nak keluar? Okey. Belakang sikit. Allahu Akbar. Belakang lagi. Depan sikit. Okey.
Sekarang campak kunci kereta tu. Cepat. Campak lah.
Tak boleh. Korang mana boleh tarik kereta pada cuti umum? Kau buang masa aku je lah. Bagi je lah kunci. Kau lah buang masa kau. Waktu operasi kau daripada 9 pagi sampai 9 malam. Hari biasa. Ini cuti umum. Ya Allah, mana boleh?
Dia macam-macam hal lah.
Okey, tak apa. Kami akan datang balik. Okey, datang balik. Hari biasa jangan cuti umum Okey. Okey, sekarang ni sila beredar.
Ingat sikit kereta tu.
Okey, boleh. Hati-hati. Kita jalan. Tak ada duit jangan beli kereta lah. Macam mana ni?
Macam mana? Kad EPS ada?
Ada, aku ada bawa. Come on lah brother. Ini den lah.
Cantik, aku punya. Aku pun ada. Okey. Hari ni hari Isnin kan?
Hari Senin.
Bukan cuti umum
Bukan.
Okey, ngam. Apa lagi? Jam pukul berapa?
Kau pakai jam kau tanya aku. 10 pagi.
10. Okey, ngam. Sekarang semua dah cantik.
Okey.
Dia tak ada alasan untuk alang kita tarik kita.
Li. Mama tu.
Mana? Jom.
Hey, abang manis. Ni tengok ni. Kita orang dah bawa kad EPS. Tengok.
Hari ni hari Isnin, 10 pagi, bukan cuti umum. Sekarang jangan banyak cakap, bagi kunci sebelum siku lekat di pipimu.
Labu-labi. Kau nak kunci kereta? Tak boleh.
Apa salah pula?
Apa pasal pula? Kau nak tahu kenapa?
Nak lah.
Okey. Mes ni. Dekat sikit. Apa dia? Cerita je lah. Sebabnya korang dua tak bagi notis pemilikan semula daripada bank atau mahkamah. Itulah masalahnya.
Ada.
Ada tak? Tak ada. Dan macam mana? Tarik kereta guna mulut. Mana boleh, kena ada hitam dan putih. Janganlah macam ni. Ni ada lagi satu. Ada lagi? Ada. Apa dia? Cerita. Korang tak boleh tarik kereta aku sebab aku dah bayar 75% daripada hutang. Ni, aku nak tanya. Kereta yang korang cari tu, nombor plate dia apa? BAD 7444. Bagus satu, pandai. Kereta aku BAB.
Abu. Kau lah ni.
Oi. Macam mana kau cek? Kan aku dah cakap cek dulu. Kan ada masalah ni.
Bang.
Aduh.
Abang jangan marah sangat bang. Nanti kena jual. Kami minta maaf bang.
Tak marah bang. Tak adalah marah mana. Ni aku nak beritahu ni. Kerja korang ni, tarik kereta ada prosedur dia. Bukannya datang minta kunci kereta lepas tu turun tarik. Okay, faham? Tak elok macam tu.
Ya. Tak apa-apa.
Faham?
Faham. Jangan
Okey. Okey, selamat. Okay, selamat. Bang, bawa kereta elok dulu bang. Itulah kau, aku dah cakap. Cek.
Satu masa dulu, penarik kereta ni dah jadi macam raja. Datang tarik kereta, tak ada surat, pakaian huru-hara, dengan gelang, dengan bajunya terbuka sampai ke dada. Bila dia kereta dah ditarik, kadang-kadang tak sampai pula kepada tempat simpan kereta. Hilang tak tahu ke mana. Ingat, walaupun kad EPS dah ada, surat dari mahkamah pun ada. Tapi kena cek juga sama ada kad itu tally tak dengan orang yang tarik. Kadang-kadang orang lain. Kadang-kadang kad pun photostat, surat pun photostat pun ada. Ya, tengok betul-betul nama tu betul ke tidak dengan nama yang surat tu keluar dan nama EPS-nya. Lepas tu, mereka yang menarik pun kena tarik kereta dengan memberi masa yang berpatutan lah. Nak ambil barang, kadang-kadang tak benar ambil barang, terus ragut, terus bawa lari kereta. Jadi ingat, santok kini kita kena tahu hak kita supaya kita tidak diambil kesempatan.